webinar and thank the panel of esteemed speakers who have agreed to join us for this event. Before we start, just a couple of quick housekeeping items for the webinar. The webinar is being recorded and the recording of the session may be available on request after the session. And should you have any questions, please feel free to put them in the Q&A section that you will see on your screen. And we will try to take as many of them as possible at the end of the session. And so without much further ado, let's start with the proceedings for the day. I would like to invite Mr. D.M. Sukthankar, who is an integral member of the Mumbai Elders, to give an introduction to this webinar. Mr. Sukthankar, the floor is yours.
Thank you, Pratik. Hi, everybody, and welcome to this webinar. As you know, this is an interactive webinar where the topic is India's constitution, the quasi, the India's constitution, the quasi-federal structure under stress. And the topic is actually, or the discussion of the webinar actually is based on, or sort of springs from the book recently written by Dr. Madhav Gokhale, who is one of the persons who is going to introduce the book. And therefore, I will not virtually say anything about the book. Madhav has been always a prolific writer. He has written about over 25 books and contributed over 500 articles to different journals, etc., covering various kinds of topics of public interest. And he has always been putting forward out-of-the-box ideas. He has also been very forthright in the expression of his views on various matters. So it will be an interesting presentation whereafter, of course, the discussion, so to say, or the other panelists aided by Mr. Justice B.N. Srikrishna and Justice. Hello. Yeah, am I audible?
Yes, sir. Yes.
And Justice Gautam Patel and Mr. Ajit Ranade will be then discussing on the subject. And since the book itself has a very expressive title, and that is a federal union of states, as Dr. Gokhale says, federal union of states outlines challenges and opportunities. So I suppose the discussion by the panelists will focus on all these three different aspects. Now let me quickly introduce each one of the panelists. To begin with, of course, Mr. Justice B.N. Srikrishna, with whom most of us in Mumbai are familiar, mainly because he has been a judge of the Bombay High Court for almost 11, 12 years before he was elevated to the Supreme Court. And in the course of his being the judge here, he had to, towards the end of his tenure in Mumbai High Court, handle a rather tricky and difficult assignment of being the one-man commission on Mumbai riots, which were unfortunately witnessed by the city. I wouldn't go into that, but I just wanted to refer to the fact that Justice Srikrishna has been presiding over or has been a single member commission or committee, including the 6th Pay Commission, and the latest one probably is on the privacy aspect or the data protection aspect, etc., etc. And therefore, I think he has handled various public policy matters very deftly, and he is probably a very apt person to chair this session. I will formally request him later on to chair the session. Followed now by Justice Gautam Patel, who is also a personal friend of mine. And he was just here. I don't see him on the screen, but
I'm here.
he has also been practicing in the Mumbai High Court and has dealt with particularly several environmental litigations and also, of course, commercial and civil and other issues and other matters in contention. So I would say that Gautam Patel is also equally appropriate choice, so to say, to be a panelist today. And then Dr. Ajit Ranade, also a good friend of mine. Till recently, he was in Mumbai, now just shifted to Pune as Vice-Chancellor of the famous Gokhale Institute of Economics and Politics, about which all of us have definitely heard. And before that, he was working for the House of Birlas. And he has had vast experience of advising on various economic issues, and also has been a member of different committees appointed by the government or by the Reserve Bank, etc., etc. And he has acquitted himself as a professional economist very competently. And therefore, apart from the two distinguished judges, we have a person from the field of economics and general public policy, if I may say so. So that is the panel. And finally, I would like to also introduce Srimati Seema Mustafa, who is going to moderate the discussion, which will be, as I said, decided over by Justice Srikrishna. And she will be the one who will be probably addressing some questions or raising issues to which the panelists would respond. And she has been a veteran journalist. She is at present the editor of The Citizen and has worked her way up through various dailies and periodicals, including Economic Times and Asian Age and Patriot, etc., etc. So I don't think we could have found a better person to sort of be the moderator. That's about all. That is the introduction which I wanted, which was interested to me. I would only end up by saying that we all of us have to consciously stick to the various timelines which have been laid down. And only thing I forgot to mention was that this webinar has been organized by Mumbai Elders, which is an informal association of retired citizens. And we have been, as Mumbai Elders, having these kind of webinars or discussions off and on. So I will now hand over to Justice Srikrishna to kindly formally set the ball rolling along with Srimati Seema Mustafa. Thank you.
Thank you. Thank you, Mr. Sukunankar. Greetings on this Sunday morning to all my co-panelists and all the persons who have logged in and are interested in participating one way by listening to the dialogue. The next item on the agenda I don't have to introduce my co-panelists. Mr. Srikrishna has done it admirably well in the little time that was given to him to do this work. Now, the next item on the agenda is requesting Dr. Gokhale to speak about the book and what does it really highlight and the fault line challenges and opportunities of rectifying the fault lines. Dr. Gokhale, the floor is yours.
Thank you, Mr. Chairman, and the distinguished panel of discussants, and ladies and gentlemen. The situation in respect of center-state relations or federalism has deteriorated considerably since the time I started writing this book. In fact, it is deteriorating every day. There is more of rhetoricism on federalism every day, little realizing that India is not a federation. India is a union of states, which was clearly brought out by Ambedkar in his more than one speeches in the Constituent Assembly. But it has a distinction of being one in which, though it is a union of states, it has all the features of a federal constitution. Important one being division of responsibility between the center and the states as enunciated in the 7th schedule. In fact, this is the most comprehensive division as compared to any other so-called federal structure in the world. Therefore, whole idea was that it should lead to as few problems in terms of implementation as possible, but over a period of time, we find that a number of issues have come up which are finding it difficult to deal with. As I see, the main reason for this being the overpowering central government with a larger than life image of the Prime Minister of the present BJP government. Interestingly, the same situation was there when Indira Gandhi presided over the government years ago. Again, center-state relations were under tremendous strain. And therefore, one has to take into account the fact that this situation is going to arise in our democracy from time to time, and institutional mechanisms must take care of it in such a way that irrespective of the political ups and downs, the center-state relations continue on an even keel, and there are no undue stresses in the system. Largely, this is also because the political dialogue between the states and the center has practically broken down. There is no political dialogue whatsoever, and whatever it is during the elections is at such a low level that leaders, when they come together in any consultative forums, find it very difficult to forget what was said a few days ago, a few years ago by somebody else in the meeting. And therefore, problem is a peculiar problem of India in one sense as compared to any other similar structure, and where to find the manner in which to deal with it. What I'm trying to do in this very short presentation is to give you an idea of what these fault lines are. I have talked about 15 fault lines in this book, but I'm going to deal with just 5 or 6 of them, which I think are the most important emerging problems in India. The first one, the longest fault line, is Jammu and Kashmir. This has been with us from independence. I largely attribute this problem to our own creation. This problem was created by us over a period of last 70 years, and I have dealt with it at great length because I find that there is a great deal of misunderstanding on this subject. Not only misreading of history, misinterpretation of history, misinformation, but also deliberate misinterpretation in a manner in which people have come to view this problem. For example, Article 370. Article 370 is common parlance, considered as one which gives special privileges to Jammu and Kashmir. It does not give special privileges to Jammu and Kashmir. In fact, Supreme Court has declared it more than once that this was a specific device created to apply Indian Constitution to Jammu and Kashmir over a period of time, taking together the approval of the state government. And therefore, if this was to be a special dispensation for Jammu and Kashmir, it would not have been called a temporary provision. It would have been called a special provision, but it has not been. All other provisions in that section of the Constitution are special provisions. This is the only temporary provision which was meant to go after a period of time. And therefore, I know that I'm amongst the intellectuals and amongst those who are writers on this subject. I'm in the minority, but I believe that abrogation of Article 370 was long overdue. It should have been done long time ago. The Congress party wanted to do it for a long time, but did not have the political courage. Therefore, it is good that it has been done, but I have also pointed out that it need not have been converted into a union territory. It could have been retained as a state, but even though for various reasons it has been converted into a union territory, let us bring it back to statehood as quickly as possible. And therefore, I have given an 18-point program for normalizing the situation, though I believe that constitutionally it is now an integral part of India for the first time after abrogation of Article 370. It is time that it is emotionally brought together in India, and that is something which is awaiting awaiting action. And therefore, I have devoted considerable part of the book because there is a great deal of national and international misunderstanding on this subject. And therefore, I thought the largest fault line of the country must be dealt with at some length. The next problem which worries me, again, which is with us from 1947, is the problem of non-separation of religion from politics. I have been repeatedly talking about it. Even when the Constitution was in the initial stages of discussion, this question was raised and discussed by way of a resolution by Anant Shayanam Iyengar. And everybody agreed, except for one solitary member of the Constituent Assembly. Everybody agreed that yes, this separation must be done. Pandit Nehru was most eloquent about it. But you must have seen in his 17-year term, he never dealt with this subject. I'm not able to understand. The Constitution itself does not deal with it, though the resolution of Anand Shayanam Iyengar, duly approved by everybody, was before the Constituent Assembly. Neither the Constitution mentions it as a fundamental right, nor does it mention as a directive principles of state policy. And therefore, I have dealt with it at great length to show how it has been repeatedly neglected over a period of time. Now, of course, we are in a situation in which this government does not believe, the present government does not believe in this separation of religion and politics. And you have religion taking over the government altogether instead of the other way around. And therefore, how to deal with this situation is something which is of prime importance. And what is most disappointing, I must point out, since there are two esteemed judges in this panel, is that Supreme Court's decisions in these matters are most disappointing. At one extreme is the decision of the Supreme Court to say that this is a basic structure of the Constitution. On the other side is the so-called Hindutva judgment, on which recently I wrote an article and which I also forwarded to some of the panel, distinguished members of the panel, because I believe that even the manner in which Hindutva was devised and talked about by Savarkar was not discussed by the Supreme Court. And now 22 years, 25 years have gone by, but that judgment has still not been reviewed. There are various other judgments of the Supreme Court which also give a conflicting signals in respect of secularism, though it is called a basic structure of the Constitution. Therefore, according to me, this is a very, very important issue. The next problem which I must refer to is the increasing subnationalism. I have no problem with the linguistic states because there is no other alternative than reorganizing the country on the basis of language. But all the worries which were there right from beginning, that this will lead to subnationalism coming up to the forefront, is something which is coming true now. And irrespective of which political party is in power, we are not able to deal with this problem. Take the case of Yamuna Satluj Ring Canal, for example. Canal which was dug up, all the land acquisition was completed, and then it was completely done away with, and the Punjab government passed resolutions to say, Punjab legislature passed resolutions to say that the agreements are not binding on them. And those same political party was in power in both center and the state. They were not able to take care of these situations. You have border clashes, as if it is India and China, between India and China. You have border clashes. You have situations where people from one state to another are finding it difficult to agree, to reside, to find employment. Again, pardon my saying so, I blame Supreme Court for this. There was a judgment of the full Supreme Court to say that there is one domicile in the country, and that is a national domicile. That was done away with by a subsequent judgment of the Supreme Court to say there will be state domiciles. And now you have a situation in which the states are saying, unless you are a resident of my state, I will not give you the certain facilities. It has come to a stage where 75%, 80% of employment is being reserved only for people residing in that state. A recent case of this kind was in Haryana. 4 states have already passed resolutions. Haryana case went before the Supreme Court. Quite frankly, as a commoner, I find it very difficult to agree with the judgment of the Supreme Court. It was a golden opportunity for the Supreme Court to say all these 4 cases we are taking to ourselves, and a major issue will be resolved at the national level, at the Supreme Court level. Instead of that, they have done away with the stay given by the Haryana High Court. Therefore, these are very sensitive, politically sensitive matters, and these cannot be dealt with by political parties. They will have to be dealt with by an independent agency like the Supreme Court, which, according to me, is perhaps in the world the most powerful organ anywhere in the world. In the Constitution itself, Supreme Court has been given powers which no other institution has been given, and we have seen the manner in which the Supreme Court has come to rescue of the Constitution from time to time. But there are now issues which are problematic and which are pending. And lastly, within the limited time available, I will invite attention to an issue which again flows out of what I have stated, is the need for setting up a constitutional court. This has been talked about from time to time. The Law Commission of India made recommendations about this years ago. I know that simultaneously there was also a proposal to have division benches of the Supreme Court. I will not go into that part of it. It was strongly opposed by the bench by the bar in Delhi, understandably. But I think these 2 things need to be segregated. These conflicting judgments of the Supreme Court on major issues are the ones which are creating problems. And also there are major issues pending with the Supreme Court for years together. Habeas corpus petitions, Article 370, CAA, issues which are by dozens important enough for the country as a large, but which it has not been possible for the Supreme Court to take up because of its preoccupation with the appellate work on the. Therefore, I have suggested time has come make a division of the Supreme Court. Let there be the same Chief Justice of India, but there should be a clear division with 9 judges clearly set apart entirely for the constitutional work. They should sit as 9 judges together as a full court on every constitutional issue, so that we will not have these kinds of conflicting judgments on important issues which are of national significance. And therefore, these are 15 fault lines. I have one plea, which I have been repeating again and again, that this is not a political issue. This is like a mini rewriting of the constitution, but in a manner in which politics will be kept apart, rhetoric will be kept apart, and I am hoping that my book will set the ball rolling, and this seminar, this webinar will go a step further in that direction. Thank you very much.
Thank you, Mr. Gokhale. Now the next step is to invite Mustafa to start active role as the mediator of the webinar and fire questions which will provoke the panelists to say something worthwhile on the subject. Seema, over to you.
Thank you so much. I'm really honored to be here, and I don't think I have to introduce the panelists because that's been done, and they're all very eminent personalities, we all know. I wanted to be very provocative, but I thought that I wouldn't be for this time, and try and stick and flag to the book and flag some issues from there, and hope that is provocative enough. I'm glad that though you've given me the license, Justice Srikrishna. So I'm going to ask you the first question, which has arisen really from what Mr. Gokhale has just said. He's been very critical of the role of the Supreme Court, and yet at the same time, he has talked about the Supreme Court coming to the rescue of the Constitution several times. Now, that is one of the reasons why it has also been described as activists, courts, and an activist legal system, and there's always been this controversy or generated controversy, maybe by people like me in the media, that should the Supreme Court play that kind of a role? And are you overextending your brief? So would you speak to us on that?
The problem with, thank you, Seema. Let me answer it in the least provocative manner that I can. The problem with the Supreme Court today is it has bogged down in what is known as its special jurisdiction under Article 136. If you look at the Constitution dispassionately, the Constitution, just as in we had in England, where a certificate of appeal would have been given to appeal to the House of Lords and now the Supreme Court, and in respect of Privy Council, where the local High Court had to issue a certificate of appeal saying that it's a fit case to appeal. Now, our Constitution has identical provisions. Nobody seems to even know that, forget implementing it. I remember as a young lawyer in my 20s and 30s, I used to argue before and ask for a certificate of appeal. Either the same division bench which would decide the matter, they would either grant it or reject it. Only if it was rejected had I the right to move the Supreme Court. And there also 99% of the cases, the Supreme Court would not grant if they're satisfied that there is no case for appeal. Now today what is happening is, now a haircutting salon is shut down because of the something not being there. Now that man immediately goes and files an appeal under 136. And our proactive judges immediately say it's a constitutional matter, and therefore we must look into it. And then, believe me, it was back-breaking work for us in the Supreme Court come Monday and Friday to carry the burden of about 100 appeals, which had to be read overnight and we had to prepare. And also, believe me, that we used to reject about 85 to 90% of them outright because there was no substance in them. This is the problem. This is a self-created problem. And like the Frankenstein, the monster is right sitting on your head. And how do we get out of it? Yes, one of the suggestions made is that it is better to have a constitutional division of the court. Now, the point is, if you have a constitutional division, for example, take the commercial courts. Now, commercial courts was a good idea, just as in England. Now, unfortunately, Gautam will vouch for you that the commercial court is here the same thing. The judge will take one hat in the morning, afternoon, another hat, and then later on in the evening, another hat. Now, if you are not going to be able to handle it, you are trying to do, put a different label for the same judge for hearing the same matter. That is not going to work. If you have a permanent setup of constitutional matters, if you have a constitutional, the Supreme Court is a division, internal division, not that there is a watertight division on any kind, which will do only certificate, appeals on certificate and other regular original side suits under the original jurisdiction of the Supreme Court. It's handled, it's capable of being handled. As a result of this overburdening itself, Madhav is right. Supreme Court has been unable to decide whether the electoral bonds are good or bad. Every citizen wants to know why is it not possible to decide one way or the other. Take a call and say it's good, we are happy. Take a call and say it's bad, we are happy. Then the 370 issue. Innumerable numbers of writ petitions which are there. And unfortunately, what has happened is Article 32 is a fundamental right of the citizen to have his fundamental rights enforced. Now the Supreme Court is telling people who come with Article 32 and say, sorry, we have no time, please go to the High Court and have it looked at. This is, I used to say, this is like a go-down keeper saying, I have no place inside, so I will not take delivery of the goods that you have brought. It's the Chief Justice of the Supreme Court and the Honorable Judge of the Supreme Court, like Gautam Copper, saying that we have no time to do this. If 90 is my fundamental right, moving the Supreme Court itself is a fundamental right. Are you going to turn me out and say that, no, you go to the High Court? This is the problem. This is a self-created problem. And unless every right-thinking citizen, not only judges, right-thinking citizen, sit together and apply their mind carefully to this issue, this is not going to be solved. I hope I have been least provocative on the issue.
Yes, absolutely. I forgot to add that this is very informal. So if anybody wants to chip in, if you don't agree or you want to take the argument for our panelists, please let us know. Okay.
On this particular point, I'd like Justice Srikrishna to respond to a suggestion. The division of the Supreme Court, as you said, is difficult perhaps to implement, that is dividing it. But how about the US system, which is Court of Appeals, the Circuit Court of Appeals?
Yeah, correct. Now you raise the point. That is because there is perfect federalism there. Every state has a Supreme Court. And only a constitutional issue is permitted to be raised in the United States Supreme Court, that too upon a certificate issued by the Supreme Court of the United States. Now, if we had that and Delhi confined itself only to constitutional issues upon certificates, either issued by the High Court or by the Supreme Court itself, the Delhi people would be doing only constitutional matters, and all matters finally decided in the state courts, High Courts, or they call it Supreme Court in United States, would be final. There would be no further appeal at all. We have gone and botched up the situation so much that we don't know. We opened the door so wide, we just don't know where to stop it.
But is it not, sorry, is it not possible?
Do you want to come in on this?
Mr. Ranade has a question.
I'm going to move on from this because
just
it's lots of
one
issues.
short follow-up.
One issue. Yeah.
Seema, just one short.
Okay.
That the Court of Appeals doesn't have to depend on the consent of the states. The Supreme Court can just set up a Court of Appeals. The ninth, maybe 8 or 9 courts across the country. Well, and so does it not? I don't think. Do you think it needs to wait for the consent of the states for this system to implement?
You are right. Then that's going to be run into all kinds of problems. There was just this question of having an appellate bench in each state, and that has run into so much problem. And apart from that, Ajit, administration of a court is a very tricky issue. I have been in concern with that in Bombay, in Kerala, and although in Supreme Court I was not. Having too many benches is a big problem for the Chief Justice. I'm telling you because this is exactly what happened during Aurangzeb's period. He had too many sardars at different places. Later on, they started talking as if they were the sultans. This is exactly what happens in a division like this. Each Chief Justice of a bench will think that, not Chief Justice, the senior judge will think that he is the sultan himself. That creates infinite problems. I've had enough problems in Bombay. I've seen that.
Right. So do you want to add to that or should I continue, Justice Patel?
Patel, you want to, yeah. Gautam, you want to say something?
Well, I'm a little conflicted by this because I don't know whether the argument is that there should be less interference or more consistency in what the Supreme Court does and in what matter it does. Let's look at one other statistic that two other aspects. Our Supreme Court doesn't sit like the US Supreme Court or bank where the entire court decides a single case. Now, this is for operational reasons, but it's also because it is the last court of appeal, even on facts. So it has to balance both these. It can't just take the constitutional issues because it's mandated to be the last court of appeal. Now, something has to be done to do that efficiently. Now, if Dr. Godbole says we should segregate this and have a constitutional court, which is what he says at page 256 of the book, presumably this means that either you calendar this and we'll take the constitutional cases on some date. Presumably it means that the whole court, all 27 or 32 judges sit together, or you create a 9-judge or an 11-judge or a 13-judge bench. I don't know how this would actually work or how much time it would take. But there is another aspect to this, which is that you have seen a huge upsurge in the actual filings and litigations that are entering the court system. Now, somebody has to deal with them in some shape, fashion, or form. You can't, as Justice Srikrishna says, just wish them away or bounce them back somewhere else. You have to deal with them and confront them head on. Partly, it's also become a question of sheer volume. And the Supreme Court is now inundated. Let me tell you one other thing, and this is from personal experience, which Justice Srikrishna will confirm. Very often, a judge decides a point of law. Even if that is decided, the next case that has an identical point of law, the lawyer will want to argue the point all over again. Now, this is a colossal waste of time. It wasn't what used to happen earlier. It is still not happening in income tax because an income tax lawyer will say, this case is fully covered by a decision, so-and-so, so-and-so, so-and-so. If you need to challenge it higher, you go higher. In our experience in the Supreme Court and in the High Court, the same point is being re-agitated again and again and again. And two things result. One is a waste of time, which is a set of problems on its own. And second, it often leads to inconsistency when a point decided by one bench is re-agitated before another bench. Now, I don't have easy solutions to this. There are problems at various levels. But Dr. Godbole's point is that there are today issues affecting the people as a whole, constitutional issues. And those, because of this pressure, are being relegated to the sidelines, bring them back to the forefront, and find some mechanism by which this can be done. Now, whether this is his formula is workable or not, one can't say. But it's certainly something that requires a discussion if you accept that this is a requirement, that constitutional issues have to be dealt with at the highest possible level.
Right. So, Dr. Ranade, in examining this model of federalism, the author, Mr. Godbole, has pointed to Punjab, and he's pointed out that it was once the richer state, and it is now, as per capita income, and now it has slipped to the 13th position. Now, economy is always one of the issues in determining center-state relations, and this kind of a thing, and the slide down of Punjab is fed probably into the farmer's turf. Do you agree with that? And would you like to elaborate on the role of economy state-wise and determining its relations with the center?
Thank you. So, of course, Dr. Godbole is an extraordinary and exceptional scholar. So, I will try and add a bit from my list of fault lines, and perhaps they are not covered, Dr. Godbole, by the 15 that you listed. But this is from the economic lens. So on a very broad national perspective, one big, I don't know whether to call it a fault line, but this is a reality of the economy today, that 50 to 55% of the population is stuck in a sector which contributes barely 14% of national income. And this is persistent. All other economies have evolved in such a way that agriculture, people have migrated out of agriculture, and agriculture is by nature always a shrinking part of the national economy, because the services and industry sectors gain much more. But in our case, even after 75 years of independence, we still have a situation that almost 50 to 55% of the population is directly or indirectly still linked with agriculture. And it is, and at the same time, the agriculture share of income has gone down from, it used to be 35, 40%. That steadily goes down, keeps shrinking. So that is a national, I mean, this is, I think, a stark reality. And I do believe that this is also contributing to some kind of a fault line.
Right.
Second is the, what I call, for want of a better word, I don't know, it may be sounding not very politically correct to say it, but the economic center of gravity of the country is shifting south, and the political center of gravity is shifting north. What I mean by that, if you look at the per capita incomes of the southern states, even broadly speaking, are rising faster, and the per capita incomes of the northern states, including some of the eastern states, are stagnating. So much so that these ratios are now, dangerously high. It's almost the richest state to poorest state per capita, by the way, is just an average, and so it's almost 5:1. And if you go beyond income, if you look at the human development indicators, human development index indicator, HDI, even on those terms, the disparity is widening. And to further complicate the matter, it's the phenomenon of fertility and population growth rates, the phenomenon of aging. So the poorer states continue to be high fertility rates. So, when we talk about India's demography or demographic dividend, we have something like 20 million new people entering the voting age, 18 years. But a larger proportion of them are from the northern states, because the southern states have reached fertility levels of zero population growth rate. They are stabilizing. So this is a very, what should I say, very potent cocktail of disparities in incomes, per capita incomes, human development index, and fertility, not becoming uniform. So this is the second fault line, I think, which is an economic phenomenon. And Punjab, since you mentioned, is a very stark case, because Punjab was the focus of the Green Revolution, and therefore perhaps got quote unquote extra treatment or perhaps pampering. But actually, that has turned out to be a curse, because Punjab's industrial growth is one of the worst in the country. So it's what in economics it's called the Dutch disease. Countries which have to bear this curse of prosperity or whatever in one sector, like if you're an oil-rich nation, you suffer, other sectors suffer, and Punjab is a very stark example. And not to forget that this focus on Green Revolution also made soil salinity. There are problems with soil salinity. There are problems of environmental degradation. So all kinds of things. So that's right. The third. Just quickly, third fault line, I think, is perhaps I don't know if it's there in Dr. Kodbulle's list, is female participation in the labor force. India now stands among the lowest in the world. We have an expanding demography, expanding workforce, but a rapidly declining female participation in the labor force. We are down to 20%. Only 20% of the women with working age between the age of, say, 18 and 60, only 20% are in a paid job or looking for work. Right. So I think that is also. So I'll stop here, but there are these economic.
I'll come back to you. Yeah. So I'll go now back to Justice Srikrishna. Mr. Godbole, in his book, has described majoritarianism as the curse of democracy. And I'm quoting here the way he says that religious majoritarianism, according to him, is likely to be a major fault line in the coming years, but India seems to be least inclined to address the existentialism of separation of religion from politics. Now, this is something which, has been in debate in and out of courts, in the public domain. What would you say about this?
There's no doubt about that. Let me tell you something interesting. When I was doing the Rights Commission in Bombay, the then Chief Minister, the then Shiv Sena Chief Minister, Mr. Manohar Joshi, who later on became the Speaker of Lok Sabha, was in the witness box, and I was cross-examining him. I asked him, he was talking about Hindutva, Hinduism and all that. I told him, can you give me a clear definition of what you're thinking of Hindutva is, what you're thinking on Hinduism? He said, no, sir, it's a little confusing to me. I told him, all right, I'll give you a definition. Tell me whether you agree with it. I told him, your concept of Hindutva is nothing but a means to capture political fear, political power. Whereas Hinduism, according to me, is my way path to salvation. Do you agree with it? He said, Agdi khara hai sir. And that is a part of the record of my commission. He said, this is exactly what we are doing. And that is exactly what Madhav was saying, that right from the time of Savarkar till today, they have put religion in front of everybody's eyes, so that, I mean, Marx was famous for his quick that religion is the opium of the masses. So you don't see the real face of the person behind it, namely the one who is interested in politics and wants to capture political power.
Right.
So this is exactly the bane of this country.
Right. So in this, Justice Patel, the police obviously is a very important tool for maintaining law and order and not only following political signals all the time. Now, Mr. Godbole has suggested that police and public order should be placed in the concurrent list. Would you agree with that?
Yes.
And not placed in the concurrent list and not remain just confined to the states and the state list.
Yes, I would agree with that. There is no, there's a logical argument to be made there, which is very neatly presented in the book. I don't think there's a room for very much debate about that. The problem with perhaps our law enforcement agencies, let's just look at it generally, is not just religion, but that they are, many of their actions are driven less by what the legal infraction or the criminality is entails, and more by what is possible on account of a political imperative. Now, you can't weaponize statutes of criminality, and there are civil statutes that lead to criminality, even the Companies Act or the Income Tax Act. And this is not something that you should be allowed, that you should allow to enter into a political arena. A director of a prosecution such as they have in England would take an independent call on this. So I think there's a compelling argument to be made there, which Dr. Godbole makes very well here. May I just add one thing? You know, this, the 2 chapters in the book that I have found most provocative are chapters 4 and 5 towards the end. The chapter 4, where other fault lines are dealt with, and this intermixing of religion and politics. Yes. And frankly, on the question of the intermixing of religion and politics, I'm not sure that I entirely agree with the proposition, if this is in fact being made, that we need to completely compartmentalize this. As I see it, I don't think religion and politics have ever been segregated so totally in human history. There is not a single place where we have this complete separation. It's a different thing to say that there has to be a separation of church and state. That's a different concept, that the state, the nation state, doesn't lend itself to the propagation of a particular religion. But to divorce politics and religion, I'm not sure that this is even possible. The task before us is, I think, not so much to endeavor to separate them, but how we handle and what our responses should be to the muddling of religion and politics. And actually in history, whether you go back to current day United States or you go back to Martin Luther, there's always been a political, oh, actually Jesus Christ, there's always been a political dimension to any form of organized religion. This has always happened. It's really a question of power. Politics is about power, and religion is also about the maintenance and the acquisition of power. The two will coincide, the two will collide. The question is, in a constitutional framework such as ours, a democratic republic with a federal or a quasi-federal structure and secularism embedded in the constitution, what is the most appropriate response when these things happen? Should we allow one particular religion to gain ascendance over the others? to allow a process of marginalization? How do we do this? That's the tricky question, and I don't think there are simple answers to this. Sorry, I've lost audio for some reason.
No, my mistake.
Okay.
Justice Srikrishna, you want to come in on this? Also?
Yes, I have two things to say.
I could sense.
Now, can we have a situation where we can say, like Pakistan, Pakistan openly says it is an Islamic republic, right? Israel says it is a Jewish state. There is no doubt about it. But we consciously deviated from that, and we said that this is a secular. Of course, initially the word secular was not there, but it has been added subsequently during Indira Gandhi's time. Now, but all judgments of the Supreme Court say that all that has been said was already implicit in the Constitution. And our concept of secularism is not the same as what it was in Europe, namely a division, separation of church and the rulers, the king. Our concept of secularism is imported from the words of Vinoba Bhave of Sarva Dharma Samabhavatva. So if the state is doing something, it shall not be impelled by religious consideration. It's in matters of state, religion is not to enter into it. You may start by saying Saraswati Vandana, that's a different matter. Or I remember, as we used to do in the Bharatiya Vidya Bhavan, there used to be a Vandana of at least 7 religions. Do whatever you like. But when the state acts, it must act irrespective of religion. It must be agnostic to religion. Otherwise, the constitution is not workable. Otherwise, what is happening today is that we are openly saying, we means not I, at least people are saying, politicians are saying, they want the Hindu Rashtra. Now, is it something that we need to bring about? Is something that every right-thinking citizen must really consciously deliberate upon.
Dr. Ranade, I'll just bring you in. I want to go back to Justice Patel on this. Would you like to add to this? Or
Yeah, this same point, if I may.
No, just I'll come to you after Justice Patel. Don't mind, please, because the two judges, it's interesting to see what they have to say. Justice Patel.
As it's the same point. State participation or the fostering or the promotion, the evangelism by a state for a particular religion is constitutionally prohibited. This is established. But I think the point that Dr. Gokhale is making, and at least in my reading of the book, is that in every kind of political contest or struggle, we should not permit the entry of any religious element into that discourse. A party should not be able to invoke religion in that discourse. And traditionally, even in our history, we've always had, in fact, the book points this out, we've always had political parties that have been divided and created essentially on religious lines. I'm questioning the advocacy of this kind of a complete divorce in politics. If you take politics as an attempt to gain power and control from this aspect of religion, which also is a struggle for control and acquisition of power. Now, you can acquire power by a variety of means. Religion is one of them. I'm not sure that this formula of trying to separate religion from politics is even going to be workable. As I am saying, that we have to understand how we as a people are going to respond to somebody who is advocating a polarization, is advocating a marginalization and othering of some communities based only on religion. That is clearly prohibited by the Constitution. The fact that you belong to a particular religion and that religion constitutes a party is not in itself constitutionally bad.
Right.
I don't think there is any problem on that, Gautam. The question is this: as while sitting as a judge, I'm sorry, I'm making it a personal question to you. As sitting as a judge, when an issue arises of, say, Hinduism versus some other religion, are you going to judge it from the lens of your personal belief, or are you going to judge purely by constitutional principles?
Only on the constitutional principles, sir.
That is the $1 million answer.
Only on there is no question of my belief. I mean,
That's exactly what I'm pointing out.
I may be a devout and practicing atheist, but that has nothing to do with my recognition of the value of religion to a person who is before me.
Absolutely. Religion is what you believe or what he believes. And
In
he
my
has-
home.
You remember Voltaire saying that I am willing to die for your rights.
That's
No, I
correct.
don't believe in what you're saying.
That's correct. That's
Right.
correct.
Dr. Ranade, you want to speak on this or can I ask you another question?
No, on this itself,
Okay,
because
sure.
these two things are, I think, consistent. What Justice Srikrishna said, that he quoted Vinoba Bhave, Sarva Dharma Samabhava or Sarva Dharma Samanvaya. So the state, when it deals with issues, I mean, as he said, the $1 million answers, that's very crystal clear. And I think I agree with Justice Patel when he said that you can't perfectly divorce, but in pursuit of perfection, we can, of course, be approximately there, in the sense that we do have very, very well explicitly, articulated the constitutional principles against hate speech or against what he said, othering. And so, if you look at the history, how many people have been actually prosecuted under 153A? I think the record is poor. But my larger point, Seema, is the following: that since we are talking about politics of power, Marathi मध्ये म्हणतात सत्तेचे राजकारण, so the pursuit of power in politics is through the electoral democracy. So I think we have an opportunity to do electoral reforms, because it's possible for a political party today to appeal to a very narrow constituency of perhaps 20% of the voters or 15% of the voters. And the first past the post system makes it possible to grab power even with 15% of the vote. So there is a very non-linear relationship with the vote share and the seat share. Just a 2% increase in vote share gives you a 56% increase in seat share. And there is a fairly simple, in my opinion, a straightforward solution. Namely, every election should be fought in such a way that the winner has to win 50% plus one vote of the votes cast. And if nobody does that, then you have a runoff. That is, you have the first and second in the first round, nobody gets 50% plus one. Then you have a runoff election between the first and second. And again, the condition is that you must win 50% plus one of the votes cast. The voting percentage may be 60% or lower, but you have to win at least half of them to be counted as a winner.
Right.
And this is not difficult to implement. I think this has been, so I think I think there's a way out through elect. And I feel a candidate who has to appeal to a wider base so that to get a larger vote share, it's quite possible, and I think it's very likely that the appeal to religion and emotional appeal to religion will have to be diluted, or will have to be contraposed with more developmental issues. That's my belief.
Right.
But today appeal to religious sentiments is a corrupt practice under the Act.
Justice Srikrishna, how many people have been prosecuted under this? 2
of them were prosecuted till the Supreme Court. One it upheld this knocking off the election. The other one, they came out with this concept of Hindutva is a matter of life and all that. Anyway, that's another matter, another debate. I'll get into it. But basically, that is, Ajit, corruption is a way of life. Therefore, are you going to say that why do you need laws then? You need laws to let down the norm. This is the norm. Now, how many persons are prosecuted, how many are actually sent to Delhi is irrelevant. As right-thinking persons, do we think that appealing to voters to vote on a religion, is it good or bad? Parliament has said it is bad.
Right.
Now that our chaps don't implement it is our misfortune. Therefore, let's screw them up and then make sure that they implement it. That is the answer.
Right. So I'll go to the next, another fault line, starting with Justice Patel, but would like everyone to weigh in on it. The misuse of Article 356, and to what extent has this damaged this relationship and our union of states? And also interspersed in that is obviously the role of governors and the changing nature of governors from so-called eminent personalities to now political, over the years, to political appointees, completely political persons who are appointed to this. And the kind of controversy that we see between the governor and the state government to a point where it's getting increasingly hostile. And we haven't been able to check it. So Justice Patel, would you talk about 356 and what we can do about that? You're on.
I'm sorry. Actually, there's this part of the book, there's actually very little that is controversial or requires debate. This was never the envisaging in the Constitution at all, that you would use the position of the governor, which is part of your federal structure, and then the disconnect between the governor and the state government to more centralize and defederalize the union of states. Uh, that was never the intention. The problem is, what is the constitutional answer to this? And I don't think there's a simple answer to this at all. Obviously, a governor has allegiance to a certain ideology, which stems from how he's appointed, when he's appointed, who he is, and who appoints him. Increasingly, there is no coalescing between the ideologies of a particular governor and the state government itself. And this leads to this tension. Dr. Gokhale points out that you suddenly have this situation where, for the flimsiest of reasons, entire popularly elected, democratically elected governments are ejected and thrown the door. Now, this is the subject matter of challenges, but just see what happens when you bring this kind of thing, if you are ever able to bring it to a court. You have to get down into that microscopic detail of the correctness of the trigger that forced it, that forced the governor's action, whether that is justifiable or not justifiable. And there are constraints to what a court can do when it intercedes or takes up issues like this. So this becomes a major problem. If the advocacy in the book and elsewhere is that governors should exercise self-restraint, I think that's pretty much a pipe dream. It's not going to happen.
No.
It's not going to happen.
Right.
And we've seen this happening for decades, actually.
No, Madhav's solution is that the post of governor is redundant. It should be abolished. The constitutional amendment.
I was
That
just
is
coming to
correct.
That is a solution.
He wants
That
it
is-
to go.
Well, technically, then perhaps even from the president downwards, but let's not even go there. So,
Okay. So there's this other thing about Article 356, Justice Srikrishna, where, in the book also, Ambedkar has been quoted as saying that, expressing reservations about its misuse. And then you have the Sarkaria Commission also saying that it should be used very sparingly. Now, that is really looking at the goodness of man rather than protecting the country from the badness of man. Because sparingly, anybody who's sitting in Delhi would be encouraged to use. So what can be done? Do you think anything can be done?
I think after the judgment in the case of Bombay, that's a huge, long judgment, which has laid down clear-cut answers to all these questions. There is no way of personal discretion entering it. They have given an objective test on which 356, action under 356 can be charged. If it falls short, it should be set aside. If you remember, that was a very
Yes,
big
absolutely. We all refer to it all the time. It's a Bible.
It is Bombay today is a saving grace.
Yeah.
Act according to Bombay. If you have failed on Bombay, your action will be set aside. You are right. Originally, the Constitution intended that it should be self-restraint. But if that self-restraint doesn't really work, then there is a big danda that Supreme Court has given in the hands of the public at large.
Right. So to take it away.
sorry, Seema, just to add to that, when you're looking at 356, there are just two things in the opening part of 356 that are probably crucial. The title of that section has these words, failure of constitutional machinery. And the main body of sub-article 1 says that it is not possible for, if it is found that it is not possible for the state to carry on its governance in accordance with the provisions of the Constitution. Now just see how broadly this is worded. What this means, what it means in an individual, it can mean anything or nothing, depending on the fact situation in a given case. You take a hot topic such as, let us say, reservations. The central government has one view, the state government has another view. Is this a failure of constitutional machinery? Every one of these has to be tested on the actual proposals, the actual actions of the state government, and this becomes exceedingly difficult. The correct solution, as Justice Srikrishna says, is apply Bombay. Bombay does a very interesting thing over all its length. It tries to lend objectivity to what is essentially a subjective determination. And it does this actually very skillfully. We can get into all the details of Bombay. That would take the rest of the day. But that's its overarching approach. Don't make this subjective on a 1:1 each case basis. Here's an objective standard. We've laid it down, follow it.
Right. So to move
People act as if it doesn't exist. It's the law.
So to move a little bit more into Dr. Ranade's field, I just want to pin you down more on this whole thing of finance coming between relationships, federal relationships. And also we had the planning commission, became the Niti Ayog, totally marginalized. But there's always been this bickering between the states and the center on finance, on the budget, on the allocations. And that has hit at federalism all the time. And sometimes people say, chief ministers have said that's the root cause of problems with the center. So what do you think should be done? I mean, is there a revival of the planning commission that you think would resolve it, or a complete overhaul of the system, as it were?
Yeah, so this is a tough, Dr. Godbole has identified this, it's a tough fault line. Yeah. Because on one hand, the unity of the nation calls for balanced and inclusive growth. We can't have indefinite trends of disparities, regional disparities, state disparities. So if a state is lagging behind, at some point, the nation as a whole has to provide resources to fill the gap, okay? I think this is, I don't think there is any debate on this. Yeah. The question is, of course, let's not debate. I'll just park this point separately because I don't think we can debate this, that is the backwardness of a state because of the governance, the political governance in that state, or is it that it has inherent disadvantages? For example, Chhattisgarh, it is 25 or 30% tribal area, and it provides a large green cover. It has a forest cover. And now the forest laws in the country, environmental laws, require us to conserve forests because forests are carbon sinks and they provide benefits to the nation. But in doing so, Chhattisgarh says we have limits on our industrialization. So should we be penalized? Should we remain backward? I'm not, that's a larger debate, environment versus industrialization. So the nation owes some support that they should be given in compensation for providing a carbon sink or green cover to the country. So that's a very minor point, but I'm just saying there is still the open question of whether the backwardness of a state is because it did not vigorously pursue economic reforms or enlightened policies. Is it because it suffered because of bad governance, political governance? So even if you set that aside, the nation, these disparities have to. Now we actually have a good formula. It's called the Gadgil formula, and I can make a small plug-in because Gadgil was the founding director of Gokhale Institute. And the formula is very, very crystal, very, very clear and very sharp, and it is used to this day. That is the role of the Finance Commission, which is a constitutional commission, is to fill the gap, the funding gaps between what the state's needs and what the state can generate on its own. What has happened is that this Finance Commission has been overtaken by other mechanisms, such as the Pay Commission, such as the Planning Commission, the erstwhile Planning Commission, such as, for example, the central government initiating programs like universal health care or universal employment, right to rural employment guarantee schemes. So this is what Dr. Godbole also referred is the creep in the 7th schedule. Topics like labor, employment, education, even sanitation. When you have Swachh Bharat campaign. So all this is a very the camel is creeping into the tent. I don't think on this count, the states are not at fault. It's the center is at fault. Right. Under the guise of our national schemes, we have introduced so many things that is completely distorting the Finance Commission formula. So the Finance Commission is increasingly becoming, if not irrelevant, it's becoming ineffective because the Finance Commission is a very scientific way of allocating resources to ensure balanced economic development. But these other things, so we need a reform, we need a relook at the 7th schedule, and we need. That's where the problem lies. And by the way, just as an aside, I might mention that it's also related to the delimitation issue, because we've been kicking the can, and the Finance Commission has been using the formula based on the 71 census. And then I think the recent Finance Commission was asked to look at the 2011 census. But the fact is that if you keep using the old census, if you keep realistically, you should be using the 2031 census, the projected population. You will find that the share that goes to the southern states will go down because it's based on population, and of course their political representation is a question mark. So this is related to the 7th schedule.
Right. Thank you. Just a couple of more issues we are going to discuss now because we're nearing the end of time. Justice Srikrishna, the Supreme Court has recently wanted Parliament really to enact a law on mob lynchings, and then the centre sort of left it to the state. Our author, Mr. Godbole, suggests that there should be a central law. Do you think so? Do you think laws would work? I mean, we're so overburdened by law. Would it work on mob lynching specifically, or is there enough that can be used by the courts?
Frankly, according to me, we are long on laws and short on implementation. Mob lynching is even today covered by the IPC. There is no difficulty on that. Now you can, if you want, you can add a couple of sections there and finish it off. Because what is mob lynching? 10 people getting together and hammering somebody on a non-sequitur. Now that happens even today without the mob lynching. Somebody says this fellow is taking away somewhat illegally carrying something or the other. And then instead of making a complaint and asking the law and order machinery to take care of it, people become vigilantes. Now that is certainly covered by the law. You cannot take the law into your hand, however eminent citizen you may be, however politically advanced your thinking may be. The law is the law. Now, is it necessary to make another law for that? Very well, if you want to make it, then for heaven's sake, make sure that the existing laws are implemented properly. So what guarantee that the new law will be implemented properly?
Right. So on the last issue, which I'd like all the three panelists to weigh in on again, starting with Justice Patel, it's on Article 370, which has been already referred to in this discussion, in Kashmir, and whether it's temporary, it was temporary, but the way it was done, was it the right time? Would there be any right time? In terms of the legalities of the whole process, what would you say? Is it good in law or bad in law?
You're going to have to let me duck this one because those issues are pending.
Sitting judge, no, it's not fair.
I can't feel that.
I didn't realize that. So
I can't feel that.
He's right. But in fact, I was wondering why he was asked to talk about all this. Some of the issues are really political issues.
That I can't. I'm not.
Yes, so far successfully dodged the crux of the issues.
Right. So I'm sorry about that. Didn't really
that's fine.
like that. Justice Srikrishna, then it's fine.
Point is, there is no doubt, if you look at history, the development of how Article 370 was included, right from the time the Maharaja Hari Singh's accession, etc., that it was intended to be temporary, which could be done away with, subject to two things. Subject to the popular vote of the Kashmiri people. Now, our present central government has done a very remarkable thing. They played what would be very well, let me not use a strong word, they did a smart thing. They first destabilized the government, which was there, of which they were parties. Then they said constitutional machinery does not work, appointed a governor. Now, unfortunately, the governors in this country act as lackeys of the party in power. So the governor says, yes, I'm satisfied that it should be removed. The president issues an order, 370 is abrogated. Now, does it really mean what exactly was originally thought of? That the people of Kashmir should be able to tell us whether the 370 should be temporarily removed, 370 which is temporarily should be removed or not removed. Have the people said that? Now, that is the reason why 370 has been, the order has been challenged in the Supreme Court. And the Supreme Court is acting like the famous Vishwamitra Rishi, putting his hand and saying, this is not my child. That is the problem. You confront it and say, it is my child, it is not my child. Don't simply, somebody has written a lovely article saying the judicial, something like judicial adjournment or something of that sort, saying that where an inconvenient issue arises and you do not have the courage to face the people on that by a wrong order or by your own order, which you think is right, you duck it. And just as Gautam did, of course, Gautam did for the right reason. You just keep postponing it. You don't decide it. Decide it once for all. Let the people say, okay, the Supreme Court has decided. दौड़ कहाँ तक होती है? मस्जिद तक होती है ना, उसके बाद तो होती नहीं है ना दौड़. They should have done that. Now, unfortunately, दौड़ यहाँ भी नहीं, वहाँ भी नहीं, खत्म नहीं हो रहा है. So
Right.
370 is an issue that should be decided by the Supreme Court once for all. If the Supreme Court says that it is constitutionally correct, we'll all accept it. If it is said it is constitutionally incorrect, whatever the consequences, the country must face it.
Right. What do you think, Dr. Ranade?
There is also a temporal component to this. If that temporary provision was actually, taken, the action was taken at the time, at an appropriate time, the people of Kashmir would have actually expressed a preference which is to the liking of, I guess, the larger parties. But the temporal sequence, the more time that passes, then we are not sure anymore that this is the outcome. If it was during Mr. Nehru's time and I'm sticking my neck out here, we probably would have just, it would have been a done deal. But now the passage of time, now there's fear and apprehension that God knows what the outcome of the people's mandate will be. Just to draw a parallel, which is not as contentious, but it's a national issue, is the issue of reservation. I think Dr. Ambedkar also probably meant it to be temporary, right? I mean, I think there is enough indication, but we never took action on that. Today, after 75 years, it's going to be very difficult to undo the genie of reservation, but it was meant to be temporary, so I think the passage of time, sometimes they say time heals everything, but time also sometimes unheals sometimes. I don't know.
Ajit, income tax was meant to be temporary. Don't forget that. It was only a one-time measure. So was rent act in Mumbai, at least I know, was meant to be. Unfortunately, they have become as permanent as diabetes or blood pressure.
Right. Last question, which I hope will not be controversial, Justice Patel. Now become very conscious of your sitting status. So it's about the title of the book. I mean, the Constitution provides the union of the states. And Dr. Gokhale has talked about the federal union of states, very deliberately adding the word federal. Do you think we need that word now to identify the larger context in which the Union of States was placed in the Constitution?
I don't think the word itself matters. It's the concept, I think, that Mr. Gokhale is talking about. And I think that's fundamental to the structure of the Constitution, because what's your alternative? Are we going back to some sort of rulership or kingship? Or are we going back to some really noisy, uncoordinated balkanization where every state does exactly what it wants to do? That's not the concept of the Constitution. For that, as Dr. Gokhale does point out, you have to look at the manner in which the state was actually formed and brought together, and the history and the historicity of this. Without an understanding of that history, it's not possible to understand why this Constitution is framed and structured the way it is. Of course, there is to be a center, and of course, there are to be states, and there is a division of power between those states. You spoke of the 7th schedule and the different lists. It's there for a reason. The argument seems to be in the book that we seem to have abandoned the rationale behind this, and we're moving more and more towards a centralized. It's actually very peculiar. You're moving towards a great centralization, at the same time encouraging greater parochialism at a lower level, neither of which is actually in a constitutional contemplation. That, I think, is the point that is being made here. It's being made very well, actually.
Yes.
But I just wanted to come back to a point that Justice Srikrishna made about this dichotomy between existence of laws and the enforcement of laws. There is generally now an increasing impatience with the enforcement mechanism. That has a variety of reasons. Limited powers in a court to be able to achieve what they want to achieve. And of course, there is that 800-pound gorilla in the room, which is delays in actually getting an enforceable order out in the first place. That's a separate debate for another time, perhaps. But the result of this is something that you will see manifesting itself in all kinds of very peculiar forms, One of them is a local cinema. More and more, whenever I have the fortune or misfortune to watch one of these films, people around me seem to be enjoying it, but I'm appalled at what's actually being portrayed on screen, which is a sort of vigilante in uniform
Correct.
who goes around saying, sorry, your courts systems are broken, so I am going to be judge, jury, and executioner, and I'm going to enforce my concept of rightness and wrongness, or law and illegality. It's a sort of Ayn Rand kind of principle that no law applies to me except the one that I want to apply. And that's a very divisive and subversive way of looking at the maintenance of the rule of law in a constitutionally controlled country. That somehow needs to go, and that's a very, very difficult question.
Right. Any last words?
Nothing. That worked very well. That worked very well during Robin Hood and King Henry's time. Does it work today in a constitutional democracy? Is a $1 million question.
That's correct.
Seema, just an example which is very stark about the non-enforcement. The celebrated case, Prakash Singh case of police reforms, it started in 1996, and the Supreme Court, no less, judgment is dated 2006. 14 years later, I think more than 2/3 of the states are in contempt of court for not having done anything at all, not even raised a finger in implementing the order. This is, the Supreme Court of India, and this is to be implemented by state governments. So if the government themselves are in contempt, in serious contempt after 14 years,
yes.
Sorry, more than 14 years, 18 years now.
18 years.
69, the Police Reforms Commission down to Solicitor's committee which on police reforms. They huge gamut. Now, DK Basu, Supreme Court said, police fellow cannot do this, cannot do that, cannot do that. Who is really implementing? Nobody is implementing. You go to, even in a city like Mumbai, it doesn't happen. Go down to the somewhere interior and you will find that the policeman is the big boss. And there is, of course, an vigilante there.
And very clean principles, the independent, at least for transfers and postings and appointments, just have an independent commission. Even that many states are not even doing that. So I think this non-enforceability starts with even the state government themselves.
Right. Justice Patel, that's it.
No, that's
okay. Thank you so much. I have finished. We finished well in time, and thank you for the very sort of cohesive, quick, short but very sharp answers. Thank you. I'm giving this over to I don't know who, but
Mr. Srikrishna, I think.
Yes.
Okay. Thank you, Seema.
Thank you very much.
Now the crucial period of questions and answers.
Yes.
Like in Parliament, we are going to have sparks flying now. Now, Mr. Duktankar will take charge and then field the questions to whoever wants to answer or any particular identified panelist.
Yeah, unfortunately, the number of questions that have come, the number is extremely small, and most of the things which have been voiced by the people who have registered or the audience, if I might call it, are observations or comments, and therefore my task is becoming extremely difficult in terms of really identifying the questions. But there are one or two questions which were raised and which I think could be asked, and mainly to the two learned judges or former judge, and that is whether there is a unanimity as to what is a constitutional issue and what is not a constitutional issue, because Dr. Gokhale says that for deciding constitutional issues, you should have a separate mechanism within the overall umbrella of the Supreme Court. But is it something which you think is feasible in terms of clearly separating constitutional issues and their adjudication and resolution as distinguished from so-called non-constitutional issues? Is that something which is feasible, and how one can go about it?
Very good. I had the good fortune of having two eminent Supreme Court judges of the United States sitting with me on one occasion when I was the Bombay High Court judge. There was a case of some BEST overcharging somebody who had filed a writ petition. So the
Not
judge,
BST, not BST judge, MTNL.
MTNL, sorry, MTNL. One of the public utility concerns.
I was in court at that time.
Yes, sharp memory. So the question is this: when the MTNL overcharges you or doesn't give you service, now you say it's an arbitrary action which is capable of being cured under Article 14. The petition is filed. Is that a constitutional issue really? See, therefore, constitutional issue must be one which requires an interpretation of the Constitution. Here it doesn't require an interpretation because arbitrariness is already decided. What it requires is factual assessment. And if it is so, pass an appropriate relief order. Whereas if an issue arises as to what exactly is the meaning of this word in the Constitution or what exactly is the Constitution intent by a particular article, that is a constitutional issue. Otherwise, everything in this country is constitutional issue. Whereas everybody abroad in US would have filed a civil suit on that. We don't file a civil suit because we can't stand in the queue for 25 years. This is the difficulty.
Mr. Sukandar, may I just add to this? It's actually not that difficult. If you accept that there is if the Supreme Court is the final port of call or the final court of appeal, even on facts, then a question that is raised in any proceeding before it that is fact dependent, but does not challenge or question the statute itself is not a constitutional question. You need some system, obviously, manpower, which will identify the constitutional issue. Now, straightforward off the top of my head, the government decides that it's going to have greater tribunalization and creates a bunch of tribunals. Somebody challenges this statute as being ultra vires and unconstitutional. That's a constitutional challenge. But if that tribunal acted wrongly after, that's not a constitutional issue. It's really can be that cut and dry.
I think I can sort of act in a somewhat unconventional way, but ask Dr. Gokhale whether he could elaborate what exactly he had in mind when he wrote his book as to what are the constitutional issues which should be adjudicated by a separate mechanism within the overall umbrella of the Supreme Court.
As I have stated in the book, firstly, the same question, what is a constitutional issue? And there has been difference of interpretations from time to time in the Supreme Court itself. Chief Justice in certain cases said this is not a constitutional issue and I therefore no need to a constitutional court. And therefore I have suggested, again, layman suggesting it, is it possible to lay down guidelines as to manner in which constitutional issues should be identified so that common man would know how the system would operate. Secondly, that there must be some system of prioritization. That, for example, issues have been pending since 1990 in respect of certain cases. The case I talked about, Hindutva judgment, has been pending since 1995. There must be some, even in the constitutional issues, there must be some prioritization, which again the court must lay down rather than leaving it all amorphous, because most of the things in respect of Supreme Court, pardon my saying so, are amorphous. Today, people do not know what is the manner in which a particular case would be taken up for hearing or not. Take the case of election bonds, for example. This is an issue which has been pending there, and there is no reason why it was not taken up for hearing all these years. Again, whatever may be the internal mechanisms may be, but the same transparency that we are talking about in respect of other institutions should also be there in respect of the High Courts and the Supreme Court.
No, there are two different questions, Mr. Gokhale. How the Supreme Court does it and the practice and what it should be taking up where is a separate. Let me give you a straightforward example. Sabarimala is a constitutional issue and was a constitutional issue. Ayodhya was not.
Yes.
As a starkest possible example, please consider this. Ayodhya came from civil suits. This was not a constitutional issue. Sabarimala was front and center a constitutional issue and is. It deals with this. Now, once you make that divide, how to then prioritize within those divisions is a separate matter. That there could be various operational mechanisms for that. But I don't think we should confuse the question of separating constitutional from non-constitutional with the question of which gets priority. Two different considerations.
One of the issues which I have talked about in the book also is about full bench of the Supreme Court hearing all constitutional cases.
Yeah.
This is a point which has been made by some chief justices themselves, that rather than having these conflicting judgments, let the court as a whole sit in on all these cases. And therefore, I have suggested a 9-bench Supreme Court on constitutional matters.
Yeah, that is what we had. But I was talking of the basic issue as to whether there is a clarity as to what is really a constitutional issue and what is not. And I think I agree with you that some kind of clarity can be achieved by having some guidelines which enable you to distinguish between these two.
It's not fair. The Supreme Court has gone on record to say what is a constitutional issue.
That's correct.
Yeah, absolutely, they have said it. They have really separated the chap from the.
They have.
Only thing is we don't understand it or we don't read it and then keep on complaining that Supreme Court is not doing its work. It is doing its work, albeit it is hampered because of various things. Let us give the level also to you.
And there is always a class of cases which is, as Dr. Godbole says, somewhat amorphous in the sense that although it is fact-based, but there is a constitutional challenge. There may be a challenge to a portion of the Companies Act or to the Income Tax Act or any one of these things. And that could be a meld of the two. You have to decide in those marginal cases which way you want.
Actually.
Yeah, factually.
Take a call on that, that's all.
Yeah.
Well, I think since there are no other
Questions.
Other issues which have been raised or questions which have been raised, I may just, since we have a little time, the current issue of the services and who should have the final say, as it were, on transfers, the center borrowing the services of people who have been, the officers who have been allotted to certain states, that controversy which is at present raging and which has something to do with the federal structure. Now, what do you, Justice Srikrishna, feel about it?
Look, we borrowed the ICS pattern. Under the ICS pattern, it was absolutely controlled by the central government. There was no doubt at all. Now, we made a slight modification and said that, hey, we will do the selection at the center. We will appoint you, but then you will have your own cadre, that is because of various reasons, home cadre and then selection cadre and all that. Once that is done, for all intents and purposes, it is like the daughter being married to somebody and said, you will continue to stay in their house. Now, that is exactly what happened. One opportunity given to is, if the center wants something to be done, you pick up as from a state and then utilize him for the temporary period and then send him back. This is the pattern that is done.
Yeah.
So, this was working all right when there was no issue between the center and the state. The moment you have an issue between the center and state, you have this problem. It's like the daughter-in-law coming to your house. As long as you have no problem, it is no problem. But there is a problem, she will not come. You will not allow her to come. Or the husband will not allow her to go to her parents' house. This is precisely what is happening. Now, this is an issue that could have been resolved by a little bit of diplomacy. Of course, now in this current situation, it may be difficult, but this can be sorted out. I don't think all these years there was a problem, was there? From 1950 till the last 3 years, go back 3 years, was there a problem? People were happy carrying on with. People were in fact vying to get onto the selection panel. I myself sat and decided cases of that. So there was no problem at all. We would say the best man would be selected and put on the selection panel, and he would pick it up and he would get one jump, one less. The chief secretary was go-ahead secretary or something of that sort. The rules provided for that. Now, why are we trying to upset all this by this kind of a regulation or change in the rule? Does it really serve any purpose? I don't know. You people are better suited to judge it. I was never in service anywhere, so I don't know.
No, I think the problem, probably, if I have understood it correctly, was that many times certain states were overrepresented in the union government, partly because people from certain states could manage to go to the center, and in states like Maharashtra, for example, people were reluctant also to go to the center. And therefore, both things created some kind of friction and problems, but those could be handled. It was not very difficult to do so. So I think let us.
Sorry.
One solution.
If we have a minute, may I do something exceptional and put a question to both you and Mr. Gokhale for a.
Before that, let me say one solution can be. What happens in the case of banks, nationalized banks? They have a compulsory out of the zone transfer. Remember that. I don't know what state is there. So why can't you have it like that? You are in your home state or selected state, but compulsorily you must go and work in the center for this period. That would have solved the problem.
Well, here's a question for both of you, Mr. Suknankar and Mr. Gokhale, because you've both had long and distinguished careers in public service. If you accept that we have an increasingly complex society, socially, technologically, from every other perspective, my question is not actually on what is more appropriate in theory, but what is more efficient. And this is where I think Ajit will come in. Is it better to have state level cadres that only deal with states, or is there some benefit to having, as Justice Srikrishna says, a policy of, for want of a better word, cross-pollination, where you begin in one state and they are compulsorily moved to another state, and whether this applies to the police, forest services, administrative services is perhaps immaterial. Is it less efficient or more efficient? And then there's that other bugbear, which is that if you're stuck in one place, your chances of contributing to our culture of corruption are exponentially higher. So which is the more efficient method of doing this? Sorry, I'm putting a question to you.
Gokhale, would you like to respond first?
Yeah, I think if there was any time when all India services were absolutely necessary, it is the present times. Because the whole idea was that the center should not be removed from the states so much while making its policy decisions, that there must be this continuous interchange of officers between the center and the states. Unfortunately, the problem which is arisen currently with the center is that sufficient number of officers are not prepared to go to the center at all. This is quite different than this situation earlier, where people were vying with each other to go to the center. Why is it so is a question which center must ask itself, rather than making these changes in the rules, which is what I have talked about in one of my recent articles. For example, question of children's admissions, question of getting accommodation in Delhi. These are so difficult situations that people don't want to give up their comfortable life in a state and then go to the center. Rather than addressing these issues, unnecessarily, the rules are being revised in such a way that the states will have nothing to do at all, and the center can have the prerogative of withdrawing any officer at any time. This goes against the very grain of all India services. And therefore, this is something which will go against the entire principle of federalism. If I might say, India is the only federation or quasi-federation in which there is this kind of a common services recruitment and their services both by the center and the state. This was brought about by Sardar Vallabhbhai Patel with a great deal of persuasion. Mind you, all states were opposed to this. He took at least 2 or 3 meetings of the prime ministers of the provinces at that time to persuade them. The only point which had remained or which remained unanswered till the end was the control over the services. That's control in terms of transfers, etc. And Vallabhbhai Patel said that, well, as the time goes, we will be able to resolve these issues. Unfortunately, those are the very issues which have now come to the prominence again because of the manner in which dominant central government is trying to force its will on the states. And therefore, I think this controversy is totally unnecessarily made much bigger than what it ought to have been. In fact, if it pursued logically, then you will have All India services abolished altogether. Because the states will say, we don't want, as you are aware, in Jammu and Kashmir, for example, over 10 or 15 years, the state did not accept any All India service officers, and a great deal of persuasion had to be done. And since then, fortunately, all states have fallen in line and they have been accepting All India service officers. But the question which Justice Patel asked in interstate transfers, can this reduce corruption, etc.? It is increasingly difficult now with the regionalization, with the local languages becoming the language of administration. If you suddenly send a man from Uttarakhand to Maharashtra,
To Kerala.
for example, does not want anything other than its own language, or Kerala or Karnataka. So this is now next to impossible. At one time, that was considered in terms of having a statewide cadres to have regional cadres, but that idea was given up as unworkable.
Yes.
Thank you. That answers it.
Yeah, I think it is very important to understand that All India services were introduced to bring about that kind of integration, if I might call it, in the absence of a better word, in the way the state governments work, and also to enable the center to have people with ground level, field level experience coming and advising the people in the center in the process of policy making. So I think sometimes the kinds of stresses and strains which we seem to have at present tend to brush aside these basic considerations. I think we are more or less at the end of the question answer series. May I, with Justice Srikrishna's permission, or he can also formally request Chandrakant to propose a vote of thanks, or after doing your summing up, so to say.
Okay. Now I'll do the summing up in 2 minutes only.
Yeah.
I read the book with great interest. Luckily for me, last 1 week I was out of Bombay and I had a lot of time sitting at Bangalore, not doing any official work, nothing of the sort. So I finished the whole book and continuously reading it for 3 days. Now, some of the points that are made are very valid. So see, unfortunately, when we talk of federal state, we tend to think of the classic mold of, say, political thinkers like Ivor Jennings or Lasky or people in that mold. So today, originally the idea was, I am a total sovereign and I am giving you some part of my sovereignty so that we can all work together. That was the whole idea. That is how, in fact, American Independence Charter said that. In India, it was accession, pure and simple. Everybody was made to fall in line, become a part and parcel of India, whether it was an existing province or by reason of the British dominance, or even those Sansthaniks who were made to either fall in line because of persuasion or police action, as in Hyderabad. Now, therefore, to say that I have a sovereignty which I given to you is somewhat incongruous. Yes, the constitution divides the mechanism and say, in these matters, I will decide. In these matters, you will decide exclusively. In these matters, we will decide both concurrently. Now, that is the thinking of the Constitution which needs to be taken forward. Not forgetting that India is still one country.
Yeah.
India is still one country, and whether, as Ajit pointed out, if one person remains behind, it is like the Rathvatra, Jagannath Rath Yatra. If one person is incapable, then the other persons also will feel the drag on that. Therefore, we must do everything in our power possible to ensure that even those people who are lagging behind are taken along with that, with the spirit of what they call cooperative federalism. That is the concept, and we must be thankful to Dr. Godbole for having brought it out beautifully in the book, and more power to you, sir, for coming out with such excellent ideas. Thank you very much. Now I give it back to, whom do I give it back to? Mr. Naik? Yes, am I right?
Yeah.
Now, Mr. Naik to propose a vote of thanks.
Yes, and now it's my pleasant duty to thank all people who have made this possible. First of all, my dear friend Godbole for having written this book on India's federal structure. Then the main speakers, both Justice Srikrishna and Justice Gautam Patel. Thank you very much, sir, for sparing your time to be with us. Ajit Ranade is one of the persons I admire a lot for his writings in Mint newspaper. And he also represents a very famous institution, Gokhale Institution at Pune. I'm very grateful to you, Dr. Ajit Ranade, for sparing the time. Then, of course, Seema Mustafa has handled this mechanics of having a discussion over 2 hours. I'm very grateful to her. And finally, I must thank Makija, who is the real person behind our today's meeting. He arranges everything with perfection, and I'm very proud of him. And thanks to all the more than 60 people who have attended and participated as those people who have heard this. Thank you very much, all of you, sirs, for this excellent meeting which I had. Thank you very much.
Thank you.
We